Contracts are the foundation of almost every business transaction and many personal agreements in American law. You enter into contracts constantly when you click I agree on a website, when you hire a contractor, when you buy a car, when you accept a job offer. Most people have a vague sense that a contract is a promise or agreement, but contract law is far more precise than that. A legally enforceable contract requires three essential elements: offer, acceptance, and consideration. Get any one of those wrong, and you may not have a binding contract at all. This is legal education, not legal advice. Always consult a licensed attorney for guidance on your specific situation. Offer means one party makes a definite proposal to another. Acceptance means the other party agrees to the exact terms of the offer, not a modified version, not a conditional agreement. In contract law, a response that changes any term of the original offer is not acceptance. It is a counteroffer which actually rejects the original offer. Consideration is the element most people find confusing. It means each party must give something of value in exchange. Typically money, goods, services, or a promise to do or not do something. A gift is not a contract because there is no consideration flowing back to the giver. A promise to give you money for nothing in return is generally not enforceable as a contract, though gifts can sometimes be enforced under separate doctrines. The statute of frauds is a critical rule that requires certain types of contracts to be in writing to be enforceable. The original English statute dates to 1677, and every American state has its own version. Contracts that typically must be in writing include contracts for the sale of land or real estate interests, contracts that cannot be performed within 1 year, contracts for the sale of goods worth $500 or more, under Article 2 of the Uniform Commercial Code, contracts to pay someone else's debt, and marriage settlement agreements. If one of these contracts is oral and not written, it is generally unenforceable even if both parties clearly agreed. The parole evidence rule adds another layer. It restricts using outside oral statements to contradict a written contract's terms. Contracts can be void or voidable, and the distinction matters enormously. A void contract never had legal effect at all, for example, a contract to do something illegal. A voidable contract is initially valid, but can be cancelled by one party under certain circumstances. Contracts with minors are voidable at the minor's option. They can enforce the contract or walk away from it, while the adult party is bound. Contracts obtained through fraud, duress, or undue influence are voidable by the victimized party. Contracts based on mutual mistake about a fundamental fact may be voidable. Unconscionable contracts, those that are so one-sided as to be oppressively unfair, can be voided or modified by courts, though this is a high bar to meet. When someone breaches a contract, not all breaches are created equal. A material breach is significant enough that the non-breaching party is excused from their own obligations and can sue for damages. A minor or immaterial breach entitles the non-breaching party to damages, but does not excuse them from performing their own obligations. Damages in contract law are designed to put the non-breaching party in the position they would have been in had the contract been performed. These are called expectation damages or benefit of the bargain damages. Consequential damages for losses that flow from the breach may also be available if those losses were foreseeable. Courts rarely award punitive damages in contract cases. That is mostly a tort law concept. The Uniform Commercial Code, known as the UCC, has been adopted in some form by every state and governs contracts for the sale of goods. Article 2 of the UCC modifies many common law contract rules when goods, movable physical things, are involved. For services contracts, traditional common law rules apply. For mixed contracts involving both goods and services, courts generally apply the predominant purpose test to determine which body of law governs. The UCC has more flexible formation rules than common law. It allows contracts to be formed even when acceptance adds or modifies some terms, and it implies warranties of merchantability and fitness for a particular purpose. If you are a business person dealing in goods, understanding the UCC is essential. This is legal education, not advice for your specific situation.